We are back again for another installment of, I don't know, Double Fries No Slaw with Rohan Law. We'll come up with a crafty segment name. I have this under a playlist called FSU versus the ACC. And so if you haven't gotten caught up on our first couple of videos, you can certainly go do that at any time. Doug, welcome back, man. How you doing?
I'm excited to be here. Really having a good time with these videos and getting engaged with your followers. So it's been a lot of fun. I'm happy to be here.
Yeah, awesome. Well, we appreciate you for sure. We were talking just off air, and Doug had said, man, I've learned a lot over these last 90 days. And I said, man, we're just trying to pick up a little bit of what you're gleaning there. So we appreciate the work. A lot of people think we just jump on and do these videos, and that's not quite how it works. So there's a lot of research and a lot of time spent going into this. So we really do appreciate your time and effort on this. So Florida State filed a motion to dismiss North Carolina. Not that that's necessarily a shock by any means, something that pretty commonly happens if one party can try and get the judge or a judge to dismiss something. But they filed on 4 main points. You broke them down in a Twitter thread. We'll link that thread here in the description of the video. Make sure you're following Rohan Law on Twitter or wherever social media is that you use. But let's talk about the motion to dismiss, the 4 points that the Board of Trustees, Florida State, is trying to get this case thrown out on.
Yes, the Florida State Board of Trustees is answering to the complaint and the amended complaint that the ACC filed in Mecklenburg County, North Carolina. And what they're essentially saying is there's 4 main points. I broke them up into 2 basic topics on my Twitter feed. But the first thing I was saying is this idea that ACC has failed to state a claim, failed to even come out and put something in front of the court for them to be able to answer. And it's not uncommon for answers or motions to have placeholders. I consider this to be a placeholder because it kind of plays into some of the subsequent information that gets described here. I don't think it's the strongest argument, but it's one way for the judge to just throw up their hands at the very beginning and say, I don't even want to listen to this. You didn't even bring anything to me that's worthy of my consideration. Now, the reason why this is something that will have some meat on it is because then it gets into the issue of the sovereign immunity language. The sovereign immunity language is where I think we are starting to see some of the true benefits of the legal ease that's going on. But what they were saying in the second portion of their complaint was that in the race to the courthouse, which I love that term, that depiction, they failed to get a 2/3 vote from the Board of Trustees. So I didn't initially respond and react strongly to this because I needed to see what was in the bylaws. So when I came in the office early this morning and looked back through all the bylaws, that's where I was able to pull out the information as to what are the rules that govern the ACC. Remember, the ACC operates on behalf of and to the behest of the commissioners of each member or president of each member institution. So the ACC in and of itself can't do any actions, can't move forward with anything without their permission. And this lawsuit is one of the examples. I specifically cited to the code section within the bylaws that allege that. So it is true. The ACC acted outside of its scope of authority in filing this litigation without permission from 2/3 of the member institutions.
We get comments all the time that say, "Oh, this guy's a FSU fan. Can he truly be unbiased on this?" Is there any way that you could look at it from the ACC's perspective, that point specifically, and that the ACC could argue this specific instance, this lawsuit doesn't fit our threshold for needing that 2/3 vote? Like, let me play devil's advocate, I guess, on here, my favorite attorney movie of all time. But is there a chance the ACC could argue that effectively and say, like, well, yes, the members need to vote on certain things, but this wouldn't be one of those things?
That certainly is what we call a colorable argument. An attorney could get up there and try to say with a straight face that this doesn't constitute material litigation. I would look at the rest of that sentence, though, and again, yes, I am a homer. Yes, I am an FSU fan that happens to be a lawyer, as I was accused of on one of the other podcasts nationally.
That's a good way to put it.
Yeah. But If I were to make the argument, thank you, made the argument for you, that the argument is this doesn't rise to the threshold of a material litigation. Well, if not suing a member, then what is a material litigation? You didn't outline in your agreement. One of my favorite Latin phrases, and I don't remember a whole lot of them from law school, is exclusio unis, or inclusio unis est exclusio alterius. What you're saying is if you come up with a list of things and you include several things in that list, what you left out has to be things that are dissimilar. So if I have a grocery list of cornbread and barbecue sauce and beans and it sounds like I'm making a barbecue dinner, I can't also get mad that you didn't buy a sponge because you should have known that a sponge was all like those other items I included. Same thing in the law. If you make a list of what's included in there, then you give the people who are interpreting the contract some insight as to what you mean. Well, the language doesn't define what a material litigation is. But suing one of your members where the risk of losing means you may no longer exist, I think very clearly would rise to the level of material litigation. So yes, I do think that there should have been a vote, and the recourse is for the North Carolina judge to say, then this lawsuit is not proper here in North Carolina because you raced out to try to file this the day before. You ignored the 3-day notice for a meeting. You ignored taking a vote. So you didn't have the authority. This case is not a true case in existence.
I didn't know we were going to go this direction, but thinking of that makes me think, what then could other members who the conference just acted on or without their approval, could the other conference members then use that at a further date? Or if the judge throws it out, is that pretty much the end of it anyway?
Well, I can tell you one thing that could be an immediate response, and Danielle Kelly mentioned it last night on her Twitter feed, but there could be a vote of no confidence. If enough other members look at what is going on and see what a terrible job Jim Phillips is doing, then they could decide that they want to replace the commissioner and the president of the ACC. I mean, that is a realistic possibility that could come as a result of the missteps that we're seeing the ACC do.
Number 3 and number 4 on this request for dismissal kind of go into another subset of points, not so much the sovereign immunity side, but they speak to other parts of this. Can we update on those as well?
Mm-hmm. So the third portion is where they are talking about sovereign immunity existing and protecting Florida State. The reason why this is important is because sovereign immunity applies only when there is a contract, a written contract, and when there is a breach of that written contract. So here, what they're saying, going back to that prior point, if the Board of Trustees didn't vote, this is the fourth point. The fourth point is the Board of Trustees wasn't the party to the contract, and therefore there is no contract. The president signed off on it, and this is where some discovery is going to be necessary if they want to pursue this case further. But did any of the Board of Trustees meetings authorize the president to sign these agreements, these grant of rights, on behalf of the Board of Trustees? Because the Florida statute says very clearly the Board of Trustees is the entity responsible for contractual relationships with private entities, not the president. Okay, so why did the president sign it? Well, nobody looked at that statute before. That happens all the time. Florida State thought the contract was valid. Florida State thought the president was the correct party to sign the contract. This is some obscure stuff that doesn't come up until we get knee deep and elbow deep into some litigation like this. So the president thought he had the authority. The president signed the grant of rights. Now we're finding out that that may not have been the case. So if there is no contract, then you can't have a suit against any Florida State entity, because the only way to pierce the sovereign immunity statute is for there to be a breach of contract. And there's a second point to this as well. The idea that the ACC rushed out and preemptively filed this suit before the Board of Trustees met, before the Board of Trustees authorized the filing of their declaratory judgment action, that means that, again, there was not an actual breach of contract, which they didn't even allege to begin with. So the sovereign immunity statute isn't pierced. So those are two important reasons that I did not appreciate and understand when we started this process back in December as to why a North Carolina judge could be looking at this paperwork right now, could be very interested to see what the ACC is going to file in their response. Yes, there will be yet another response before answers are due. But in that response, the ACC better come with some really strong arguments on why Florida State is subject to this lawsuit in North Carolina at this time, or the North Carolina judge is going to be well within his rights to say this case is premature and should not move forward.
So we go down a rabbit hole where in North Carolina, they say, hey, the contract is null and void from the start because, again, the Board of Trustees was the one that needed to sign this. They go back, maybe discovery happens. Maybe it gets thrown out before then. I don't know how the judge will end up ruling on that. But say they go back through meeting notes of old Board of Trustees meetings, and it's never found out that the Board of Trustees gave authorization to Florida State's president to sign at that time. If the North Carolina judge was to throw that out at that point, could a Florida judge just automatically award a win with that? If the contract is no good there, can it translate back over to Florida and say, like, well, that same thing is true here. We're going to want out of this contract because there is no contract.
Absolutely. And that's the risk to North Carolina right now. We thought the first issue was just a fight over venue and jurisdiction. And there is still a component to that because the North Carolina judge is going to either dismiss the case without prejudice, meaning that ACC can regroup, gather themselves, come back and refile. The North Carolina judge could dismiss with prejudice, saying, you had your bite at the apple. This issue is done. We're not going to waste any more time on this. And the third thing that a judge could do is go ahead and issue a stay. What they're saying there is we're going to put this on the back burner. We're not sure that we're ever going to hear this in North Carolina, but we think that Florida is the appropriate jurisdiction and venue for this case. So we're going to let Florida take priority and see what happens there. So that's really the third option and the most likely option, I think, in this case. Judges don't like necessarily making final determinations, especially so early with such a limited record to decide from. So this is one way that they have to punt and decide the issue later on once they've concluded, okay, we've seen enough. I don't think that this is appropriate in North Carolina. Let's let Florida tackle it and see what happens. And if there's something that derails there and we need to pick it back up, we still have the chance to revisit this lawsuit down the road.
I asked you this off air, and so I know the answer now, but I do know that this might be a question that I've seen on Twitter or similar questions to this, and maybe would be a question that somebody would ask, so I'll try and get out in front of it. Florida State operated under this agreement for a long time, this agreement that they say was never actually signed or isn't a real agreement, or the Board of Trustees didn't sign it. And so can a court say, hey, you operated under it for this long, so you don't really have a defense now. You need to keep operating under it, whether it was valid or invalid back then anyway.
So yes, there are some examples where there might be an implied contract or there might be estoppel. We've talked about the term estoppel. We also talked before about the importance of making sure that if you are contracted to do a duty, you're given some compensation for that, some consideration, then you have to complete that contract as you were compensated. Well, some people are complaining or claiming, mostly non-Florida State fans, well, you've been getting millions of dollars throughout the years. Well, yeah, we got millions of dollars for the work we've already done, for the performance we've already made. The ACC didn't prepay us through 2036. We're not sitting on ill-gotten gains, as they've alleged, because somebody already paid us all the way through the end of the contract. We've just been paid for the work that we've done as we've gone along up until now. And so now we're looking at the future performance, and we don't want to comply with the contract for future performance. We haven't gotten any money for that future performance. So you can't stop Florida State from alleging that there is a breach at this time. Likewise, the idea of, there's an implied contract. You may not have legally signed it, but it's implied. Again, this is where sovereign immunity comes into play, because sovereign immunity will not recognize an implied contract. They only recognize actual written contracts. So to the extent that there is a breach that you can sue for, a state agency, it has to be based on an actual written contract, not an implied contract. So both of those reasons are examples of how contract law really matters in this case, and Florida State does have a strong argument for pursuing the avenue they're pursuing.
We talked about if the judge in North Carolina was to issue a stay or basically punt on the decision for the time being, would he give a reasoning for that? Would he give any credence to like any one of Florida State's arguments? And I guess my leading question there is if he was to issue a stay based on, hey, yeah, Florida State's right, like this wasn't really signed, is that something that Florida State could then use in Florida court to say like, yeah, this contract wasn't valid, or would that be the kind of their strongest argument going forth in Florida?
Sure, there is a chance for you to see what at least one jurist thinks about your arguments. So if the judge, and it's very common to include reasoning with their orders. So if the judge stays or if the judge dismisses the North Carolina complaint, he's going to list a few reasons why. And it is up to then the Florida court, completely different judge, completely different parties, they're swapped, completely different process. So it'll be up to the Florida judge to then take up this case and have it go through the process. But perhaps, if one of the arguments is the Board of Trustees didn't approve the contract, didn't sign the contract, and therefore it's invalid, well, then the Florida case is going to have a very important point to start with in their litigation and in their discovery, because let's go through the last 15 years of Board of Trustees meetings. Were there any other occasions where the president was given the opportunity to sign a contract? So maybe the Florida court, once it's deemed to be the appropriate jurisdiction and venue, then that judge will still go through the discovery process. But the Florida State legal team and the ACC legal team will have a sneak peek as to what an independent third party in North Carolina thought were some of the more persuasive arguments.
How, again, we'll get the comments that you're a Florida State fan, so this doesn't matter. But how damning is this for the ACC? Does it make you feel like if you're the ACC now, maybe are you even trying to settle even faster, or I guess we'll see what their answers are, right? Fairly soon, and we'll do another one of these and see how they can pee down their leg at that point. But, if you're the ACC at this point, are you just like, man, let's get something before they get out of here for $0?
Remember, the pleadings are unchallenged assertions that you can say whatever you want. There are legal and ethical rules. The rule of candor is that if I put something in a pleading, I have to at least believe it to be true or know that it's true. So the pleadings, while they are the assertion of Florida State, the assertion of ACC, are unchallenged, meaning they haven't been validated by the other side. They haven't been supported by facts and evidence, which is part of the discovery process. So I use all those big words to say, if true, if the allegations are true, then the ACC's lawsuit is dead in the water. These points are that important. If the ACC failed to secure a signed contract from the Board of Trustees, as is the legal requirement in the state of Florida, then there is no contract to violate. That's a very big deal.
Yeah. Anything else from these latest updates, or if not, just kind of where are we in the timeline? What's next, and what should we kind of expect kind of the next move for either side to be?
Well, we want your fans to know that, we're not jumping on a video every chance we get. We ignored or chose not to do the video the last time when the motion to keep the documents or to reveal the documents that was filed by FSU. We didn't jump on a video there. But what's important is that the ESPN is now getting dragged into this litigation as well, and they need to file a response brief to the issue of whether or not those documents that the ACC wants to keep secret and hidden remain secret and hidden. And what we pointed out in our Twitter review of those documents is that the ESPN contract specifically stated, remember we've talked about choice of law, the ESPN contract specifically said this contract will be subject to whichever laws the member institutions reside in and interpreted according to their laws. Well, Florida State has the Sunshine Law. Florida State has everything wide open. So as far as ESPN and Florida State are concerned, the language of the agreement should be to reveal as much as possible. I will be very curious to see how the ESPN responds in their brief, if they assent to having these documents shared, siding with Florida State, or if they want to try and protect the ACC as much as possible and object to those documents being released and made public. That's going to be a very curious development that'll happen right around the time that the answers are due on both of these cases.
And as a reminder, that was it February 16th was the date that we were kind of looking on or around, I believe?
February 16th is when answers are due. February 25th, I believe, is when the ESPN's response brief is due on the issue of the documents being filed in secret. But if the judge before then, the judge might want, here's what I was waiting to hear later today. The judge should today or tomorrow put out an order saying, I want a response from the ACC on this motion to dismiss by Monday. And then by Monday, he should probably say, the answers are due on the 16th. I need to decide before the 16th on the issue of the motion to dismiss. This might be done by Wednesday of next week, Thursday of next week. I think this is going to be moving very quickly. And of course, if the litigation is stayed, if the complaint is dismissed, then that would mean that ESPN does not need to file their response brief on the 25th.
You can play Switzerland and put their hands up and just back out of the room quietly. Doug, I appreciate you as always for jumping on. Yeah, I agree. We Doug and I text, every other day, it seems like, with this stuff. And we're not just doing this every time something comes out. We've gone back and forth. We said we weren't doing this one. We didn't do the last one with the ESPN stuff. And so we tried to do the pertinent stuff, but this felt like a pretty big one. Could get rid of one complaint pretty quickly here in a week or so, like Doug pointed out. So, Doug, tell everybody a little bit about Rohan Law, as we like to do, and then we'll wrap this up and until next time.
Thanks, TJ. Yeah, we're an Atlanta law firm representing injured workers and people who have been arrested. So if you're a nole in the Atlanta area or have friends and family in and around Georgia and you want somebody to come alongside you, I have my own practice here. We've been open for 11 years now. I've been practicing for 20, and we want to make sure that we're your best friends on your worst day. If you're calling my office, it's because you have not had a good series of events that have happened to you, and so we want to make sure that we can pick you up and help you through the difficult times that are moving forward. And in the meantime, follow us on Twitter and follow us on social media. You may not need me today, but hopefully if somebody mentions that they're going through a difficult time, you'll remember that Rohan Law is in Georgia and ready to help out your friends and family.
The most fascinating thing to me outside of this entire case and everything that's going down is, now people, anytime something happens, it could be the biggest thing, the smallest thing, like, hey, we're meeting at, the judge puts out like, hey, lunch is at 12. Everybody tags, like, what's Rohan Law think about that? Like their tag. And so listen, if you don't have a Twitter, go to Twitter. I'll link Doug and Rohan Law's Twitter. They're in the description of the video. Go follow. Really good updates on everything that's going on. And then just good FSU updates in general. When we're not fighting for our lives here in the ACC. Doug, thank you so much for hanging out. I really do appreciate it.
My pleasure, TJ. Go Noles.
Thanks, buddy.